Right, so big round of applause for Rodney and for John. So John is going to give us a presentation on the right to lawful rebellion. John is a founding member of the Magna Carta Society. Yes, big round of applause. He's a retired policeman. He's got an encyclopedic knowledge of the British Constitution, common law, statute, and historical context, which will help us understand all of these talks. So, over to John.
I'm going to talk about law, not politics. There was a certain amount of law in the previous presentation. Rodney woke me up. I read one of his books 15 years ago, and I thank him for it. I'll do it in person when I get the opportunity. What I will say to him is in actual fact, the European Union Treaty is invalid because it was obtained by fraud. Mr. Heath was a traitor. There's a legal opinion to the effect that there's a convention on treaties. If one party is acting fraudulently, the whole thing's void, and it goes away. You notice I'm wearing a poppy. Now, what I'm going to do is I'm going to try and create a vision of a new society formed on the basis of lawful self-defence. It's something we had within living memory, and it's been taken away from us, and it's been done by stealth. And the object of the exercise is to tell you what happened to the right to bear arms, how it can be recovered, and the reason for doing that is the only constraint on government is trial by battle, trial by combat. And that's reflected in the textbooks. I'll be quoting a textbook by an expert on the Constitution by the name of Professor Dicey, and he said in certain circumstances it would be right to rise up. It would be right to rise up. And he puts forward a proposition that politicians have a problem with that because they don't know how far to push the envelope. It's an inexact science. It's an inexact science. So if the population have got the right to rise up, they need to know about it, and the politicians need to take it on board. And there could be circumstances where just the threat of an insurrection should be sufficient to cause the politicians to draw back. And you could argue that's where we are now. 83%, was it 93%, don't want to be in the EU. I'm going to be assisted in this talk by my long-term friend. I've known him for 30 years, Richard Law, who's a knowledge expert on firearms law. I've known him for 30 years. He didn't speak to me for the first 10 because I was a policeman. He didn't trust a policeman. But we got over it. And we'll have a question and answer session at the end because it's a new field for many people and they don't know much about it. The right to lawful rebellion. Which button do I press to go? Is it page? That one? I'm going to talk about authorities. First, I'm going to talk about the rights of Englishmen. The last is the right to bear arms, so that's what we're coming up to. I'm going to talk about the rights of Englishmen, and the sources of these authorities are law books. Law books record history, and the further you go back in time, the closer law books and history books come together. Because some of the sources that we go back to, there weren't any law books that were just history books. So we've got the next picture. Bit of a hero of mine, William Blackstone, a jurist writing in the 1750s, codified the common law, big supporter of the common law, and his textbooks are authoritative. In other words, the courts refer to them. If you say Blackstone, the courts know what it means. So the rights of Englishmen, here we go. And English women and Scotsmen and Scotswomen, obviously. In these several articles consist the rights, or as they're frequently termed, the liberties of Englishmen. Liberties is more generally talked of than thoroughly understood, and yet highly necessary to be perfectly known and considered by every man of rank or property. So that's what we're doing. We're sharing this information. Lest his ignorance of the points whereupon they are founded should hurry him into faction and licentiousness on the one hand, or a pusillanimous indifference and criminal submission on the other. So that's Blackstone saying if you don't know about it, you can't claim it, and it'll be taken away. Now, I'm conscious of the time, so what I'm going to do is go quite quickly through these slides. If you want to read them in detail, they will be on the video. You can pause the video and read them. Some people just look at the speaker, so they take in what he's saying, and don't get distracted by the slide. So you've got a choice. And we've seen that these rights consist primarily of free enjoyment of personal security, personal liberty and private property. As long as these remain inviolate, the subject is perfectly free, and every species of compulsive tyranny and oppression must act in opposition to one another's rights, having no other object on which it can be possibly employed. Preserve these from violation, it's necessary that the Constitution of Parliament be supported in full vigour and limits certainly known be set on the royal prerogative. So we'll talk about Parliament. Now, how do you keep Parliament honest? How do you keep Parliament from being political and not legal? Because that's what they are, aren't they? They're political, not legal. There's a textbook, Erskine May Parliamentary Practice. The old ones you can quite commonly find quite cheaply, and the older you go back, the more reliable it is, because the thing's been corrupted in recent years. So if you need to quote a textbook as far as Parliament's concerned, there it is, Erskine May. And here's a quote from a 1920 version of Erskine May. The present constitution of Parliament has been the growth of many centuries. Its origin history, though obscured by the remoteness of the times, the imperfect records of a dark period in the annals of Europe, have been traced back to the free councils of our Saxon ancestors. The popular character of these institutions was subverted for a time by the Norman conquest, but the peoples of England were Saxon by birth, in language and in spirit, and gradually recovered their ancient share in the councils of the state. And that's what we need to do, isn't it? Recover our share in the council of the state. Because currently, you vote for the blighter, and he does what he likes, doesn't he? Yes. Yeah. Step by step, the legislature has assumed its present form and character, and after many changes, its constitution is now defined by the clear and written law, the deep-trod footmarks of ancient custom. Common law, isn't it? Common law is what we've done commonly around here for many hundreds, thousands of years. And the older a common law rule is, the stronger it is, because the more generations of our ancestors have accepted it. And it's reflected in jury decisions largely. You imagine generations of juries going back in time. They may be poor, they may need a wash, but they've had the same experiences, birth, death, marriage, that sort of thing, and they know what's right. And it's the role of the judges to write down the decisions of juries and say that's what the law is. Murder is the classic example. There's no act of parliament that says you mustn't murder people. It's just wrong, and the juries have said so. Let's go back again. The royal prerogative. Now here's a problem. Here's the problem. You could argue that the country is run by the royal prerogative by the Privy Council. Who's heard of the Privy Council? Not everybody, but they are a secret government, and lots of what appear to be acts of parliament, in fact, are decided by the Privy Council. And the fact that it's privy is the problem, because it's secret. So right honourable, people described as right honourable as a member of it, and they do things in secret. And that's inherently wrong, because we don't have a say in their councils, do we? What's going on? So the royal prerogative are a series of powers, the historic powers that formerly exercised by the monarch acting alone, but which in reality are exercised by government ministers. They enable government ministers to rule virtually by decree without the backing of or consultation with Parliament in many areas not covered by statute. A.V. Dicey, Professor of Law, has described the royal prerogative as the residue of discretionary or arbitrary authority which at any given time is legally left in the hands of the Crown. The Citizen Guides to Government 2014. That's not a textbook, that's a government website. Okay? And the reason I put that in, it shows how they've got away with it, haven't they? They're saying they've got arbitrary powers exercised by other than the Crown. And that's the problem, because people haven't read Erskine May and said, no, the law is what tradition is, what the custom is. They're doing what they like now. And that's the reason I put that slide in. Now we come to the right to bear arms. And lastly, to vindicate these rights when actually violated or attacked, the subjects of England are entitled, in the first place, to the regular administration and free course of justice in the courts. Okay? Because we don't have the blood feud anymore. Yeah, we don't have the blood feud. The blood feud was a problem because it could go on for many generations. It was unpleasant and it was ineffective. When we started having a single king, Alfred the Great, for example, his role was to maintain the peace throughout the whole country. And the blood feud was suppressed. And if somebody did a wrong to you, you're expected to go to court, and the king would obtain, provide justice for you. Do we have that now? No, we don't. About 1,400 Rotherham children sexually exploited. Yeah, where I'm coming from. Yeah, a lot of those have been to policemen and said, "Excuse me, Mr. Policeman, I've been ill-treated," and what's happened? Nothing. Nothing. So if they're not careful, we will go back to the blood feud. I'm surprised it hasn't happened. It may have happened and we won't know about it. Who knows what goes on in back alleys? You know, committees of men with baseball bats and ski masks and so on. It could well be going on. Blackstone on the rights of Englishmen, next to the right of petitioning the King and Parliament for redress of grievances. Who recognises that? We do. It's got the title at the top. It's Magna Carta, hasn't it? Magna Carta didn't give us rights; it acknowledged them. As Rodney said, and in fact, it refers back to the Saxon laws, the law of Alfred in the 830s. Quick talk about the Magna Carta Society, and this shows how Magna Carta was actually used. Well, there's a man exercising the right to bear arms. That's a chap called Bob Lomas. In 1998, he formed the Magna Carta Society. He was he's an ex-serviceman, disillusioned with politics. It's a legal problem we've got. Politicians aren't following the law. What should we do about it? And then he read Magna Carta. And it's the famous chapter 61 is the right to rebel. The right to rebel. So what he did, he founded the Magna Carta Society, and we did some research. I was a humble researcher at the time, and we summarised the evidence to petition the Queen under chapter 61. I'll just talk about the right to rebel. The right to rebel is based on the duty of allegiance. I thought, and I've taken the oath of allegiance as a policeman as another rank in the army, and it's not first in the army, so I've taken it 3 times. I thought it was for life, and you couldn't withdraw your allegiance. But you can, because it's a contract. And the contract works both ways, and if the person that you swear allegiance to doesn't fulfil their part of the contract, you can withdraw. And that's called diffidatio, or defiance. And in common law, if a person declared diffidatio, they were escorted to the... If it was to an individual lord, they would escort you to the edge of his territory, and they would sign up with the neighbouring lord. Or if they were withdrawing their allegiance to the sovereign, they would be escorted to the coast, and they were allowed to sail their way to the next country. Talking about the Magna Carta Society, founded by Bob Lomas in 1999 to restore the British Constitution as a matter of law, not politics. Producer of a research paper which was endorsed by Leland Price QC. There are only 3 QCs that specialise in constitutional law because cases are so rare. So 1 out of 3 was spoken to, and he agreed with us. And it petitioned all members of the Lords and the Commons to uphold the Declaration of Rights, 1688, and to refuse further integration with the EU. The Declaration of Rights is exactly the same as Magna Carta. It was obtained by trial by combat. So go back to 1215. 1215, King John was very unpopular. The country rose up against him. The majority of the barons were against him, and they decided that enough's enough, we'll put him in his place. They declared diffidatio, they went and saw a vicar in Wendover, and then they surrounded Windsor Castle. And John looked out at the battlements of Windsor Castle and found that he was on a loser, because there was too many of them. He couldn't afford money for mercenaries, he spent all the money. He didn't have any natural supporters, so really he had to agree. Now some people say that Magna Carta was retained under duress, and therefore it's void. No, because that doesn't apply to sovereigns, because title to land is settled by trial by combat. There wasn't actually a battle, because King John counted the numbers and said, oh, I'm on a loser. And a similar thing happened in 1688. James II wanted to turn the country Catholic. The country didn't want to become Catholic. The next in line was Mary, who was married to William of Orange over in Holland. She was invited to come back, but before she came back, her husband stepped in. In those days, women's lib wasn't what it is now. And William wrote a letter to say, well, I'll come back with Mary if you invite me, but I will agree to what you decide as the new arrangements for running the country. So in the same way as the barons in 1215 got together and wrote down what they wanted, a similar procedure was exercised in 1688. There was a convention. It divided into committees, and the committees, just like the modern committee in Parliament, they considered the 13 heads of grievance, which became the 13 articles of the Bill of Rights. Article 7 of the Bill of Rights is the right to bear arms. There's the front page of the petition to the Queen. She was given it in February 2001. And here's what it said. This is the core. It's our humble duty to petition your Majesty to withhold the royal assent from any parliamentary bill which attempts to ratify the Treaty of Nice, unless and until the people of the United Kingdom have given clear and specific approval, to uphold and preserve the rights, freedoms and customs of your law subject as set out in Magna Carta, and the Declaration of Rights which you, your sovereign, swore before the nation to uphold, and preserving your coronation oath. Magna Carta, Bill of Rights, peace treaties between people and crown, nothing to do with Parliament. There wasn't a Parliament in 1215 anyway, and there wasn't in 1688 either, because an essential ingredient of a Parliament is the king, and James II had taken fright and done a bunch to France. Here's a list of the peers. It's come out a bit small. Reported in the press, you may not have seen it. And the Queen's personal secretary wrote back, I am commanded by the Queen to reply to your letter of the 23rd of March and the accompanying petition to Her Majesty about the Treaty of Nice. The Queen continues to give the issue her closest attention. She is well aware of the strength of feeling which European treaties such as the Treaty of Nice cause. As a constitutional sovereign, Her Majesty is advised by our government who support this treaty. As I'm sure you know, the Treaty of Nice cannot be enter force until it's been ratified by all member states. In other words, she didn't do what she was told. She didn't say, I'm going to uphold Magna Carta and the Bill of Rights. And what happens next? Do you recognise this? There we are. That's where it all started. And it's a matter of law. It's not politics. There's the Article 61 of Magna Carta. Admonishes, tells the people to rise up against the monarch if and when such grievance is not corrected. Can't kill the king, but you can seize his property. You can seize his taxes, so not paying council tax, that's what that's based on. If you could not pay income tax, that would be a good one. If you could not pay fuel duty by using red diesel or whatever, that would be covered. And the people who were arrested at Birkenhead when the judge was arrested, that's their defence, and that's not over. I've had a chat with Malcolm Massey in the interval. Time has gone by, we've got new information, and we're going to readdress what happened to Judge Peake. It's not forgotten. A lot of things in the last year, or the last 2 years, the BCG we've been waiting for Roger. Yes, the lady at the front there, we've been waiting for Roger. Roger is unwell. I don't know how long he's been unwell, but he's unwell. We've given him the benefit of the doubt and waited, and now we're carrying on. Now remember, so I'm going to teach you how to protect your rights. Well, in order to protect your rights, you need to know them, and they're written down. If it's written down in a textbook, it's precedent, and the basis of the common law is precedent, going what's gone before. If anybody says to you the common law can be repealed, they're just a thug. They're just a criminal. They're threatening force against you. My gang's bigger than your gang. Okay. In an adversarial legal system, we need test cases. And I'm glad to say Malcolm at the back there has consented that the time has come to clear his name. He was arrested for something that he did which wasn't unlawful. And it wasn't unlawful because, yes, he made a disturbance in the magistrate in a county court, but the policewoman who arrested him was told, yes, I'm acting under Chapter 61 of Magna Carta, and she completely ignored it. She was young in service, didn't really know what she was doing. An older policeman was assigned to be officer in the case. He ignored it. He didn't investigate it. And then the file was passed to the Crown Prosecution Service. They were told about Chapter 61. They ignored it. They didn't take it on board. And what they've done is they've conspired to pervert the course of justice. And the reason is there are two sorts of evidence in an investigation. Evidence that makes a person look guilty, and exculpatory evidence that gets them off. And for a policeman to only go down one route, he's perverting the course of justice because he's not looking at the other stuff. So that's what we're taking on board. In 2005, there was an Attorney General's practice direction. The Attorney General is the Crown's principal law officer, and he or she, when a case comes through on appeal or to the House of Lords, which affects the way the legal profession should operate, he or she issues an instruction. So that's an Attorney General's practice direction, and there's a practice direction from 2005 about this. All viable lines of inquiry have got to be investigated, and evidence obtained in those lines of inquiry have got to be reported to the CPS. So that didn't happen, and what that means is there's a fundamental in the defect in the case where Malcolm was convicted of allegedly assaulting this WPC. So it's void. So we're going down that route. So you heard it here first. We just agreed with Malcolm. The BCG is fighting back. We wanted trial by jury because originally they were charged with violent disorder, which is a public order offence, one down from riot, and they would have got a jury trial. And jury nullification would have applied. I'm sure you're aware of jury nullification. Jury nullification is the common law concept that the jury can decide, did he do it, and would it be just to convict him? Would it be just to convict him? Now, modern juries at Crown Courts aren't told that. Anyone done jury service? Yes? Quite a reasonable number. Yes, there we are. correct me if I'm wrong, but the judge didn't tell you about that, did he? No, he just said, I will tell you what the law is, you decide whether you think he did it. Okay, but no, that's not right. The common law principle is that the jury can decide, did he do it, and would it be right to convict him? And the classic example is, I'm left-handed, Parliament passes an act that says all left-handed people go to prison. Well, I'll plead not guilty and have a jury trial. And I'll say to the jury, well, I'm left-handed, but would it be right to lock me up? And that's the other tool we've got. Okay, the other tool we've got. Never avoid jury service. It's your most important opportunity to have some influence. Vinny from is it ONS Radio suggested a law book on a UK live programme a couple of weeks ago. I bought one, 20 quid, money well spent, except, I don't know if you can see that, I couldn't get it any bigger. It's written in 1925. Professor A.V. Dicey, we referred to previously, is in fact the source for this. This is a sort of simplified textbook for him. So, A.V. Dicey, he's good in parts, but the best bit is this. Dicey was also virulently opposed to women's suffrage, proportional representation. He's a Victorian gentleman. I mean, most Victorian gentlemen would have been in that period, wouldn't they? And to the notion that citizens have the right to ignore unjust laws. So there is a notion that a citizen have a right to unjust laws, he didn't like it. Dicey viewed the necessity of establishing a stable legal system was more important than the potential injustice that would occur following unjust laws. That's a matter of opinion, isn't it? In spite of this, he did concede that there were circumstances in which it would be appropriate to resort to armed rebellion, but stated that such occasions are extremely rare. So if everyone quotes Dicey, and Dicey is the source of the concept that Parliament is supreme, well, it's not. Because remember I said at the beginning, Parliament can do what it likes, but it pushes the envelope, and eventually the people rise up and say no, and the mechanism by which they rise up is the right to rebel diffidatio. I spoke about Blackstone, the Lord Chief Justice at the beginning. His book on commentaries on the law of England is well known. There's a second one he wrote, if you can read that, the Great Charter and Charter of the Forest, Authentic Instruments in the Introductory Discourse, the history of the charters. Okay, so if anyone challenged the right to rebel, it's in this book. I haven't found this book online, but I've got a personal copy of a facsimile one, and that's quite interesting. There's a little bit of quote about Magna Carta here. It's from Winston Churchill. I'm a bit of a fan of Churchill. I won't look up, it makes me dizzy. Magna Carta, the facts embodied in it and the circumstances given rise to them were buried and misunderstood. The underlying idea of the sovereignty of the king, the law, long existing feudal custom was raised by it to a doctrine for the national state. And when in subsequent ages the state, swollen with its own authority, has attempted to ride roughshod over the rights and liberties of the subject, it's this doctrine that appeal has again and again been made and never without success. 1956. So our role, as I see it, is to make sure it works this time. There's a duplication of chapter 61, which you can look up for yourself. Here's the quote from Blackstone on diffidatio. Remember I said Blackstone's got two textbooks. He's got the commentaries on the laws of England, and he's got commentaries on Magna Carta. This is what happened. On 5th of May, the barons, having chosen their leader, this is 1215. On 5th of May, the barons, having chosen their leader, Robert Fitzwater, acclaimed by them as Marshal of the Army of God and Holy Church, performed the solemn feudal ceremony of diffidatio, renunciation of the fealty and homage, or formality indispensable before vassals could, without infamy, rage war upon their feudal overlord. Absolved from their allegiance of Wallingford by Canada, and they marched on London. Then they have a constitutional convention, because bear in mind, when you talk about barons, they're the final court of appeal. It was on 15th of June then, in the year 1215, that the conference began between John, supported by a slender following of half-hearted magnates, upon the one side, and the mail-clad barons, backed by a multitude of determined and well-armed knights, well-armed, we'll come to that. The conference lasted for 8 days, from Monday of one week till Tuesday the next. On Monday the 15th, John set seal to the demands presented to him by the barons, accepting every one of their articles, with the additional form of securitas, or executive clause vesting 25 their number full authority to constrain John by force to observe his provisions. That's what we did in 2001. Now, further on in Blackstone on the Magna Carta, we're talking about what happens, what a king... King John could have been deposed, but he was allowed to stay in post. So the question is, what happens when there's a transfer or a restating of the sovereignty of the king? What's handed on from king to king? This is what Blackstone says about it. And he's talking about William of Normandy because this comes before 1215. This context by William of Normandy, 1066 and all that, like that of Canute before, a forcible transfer of the crown of England into a new family. But the crown being so transferred, all the inherent properties of the crown were with it transferred also. For the victory obtained at Hastings, not being a victory over the nation collectively, but only over the person of Harold, the only right that the conqueror could pretend to acquire thereby was the right to possess the crown of England, not to alter the nature of government. Now, what have the EU done? They've acted like a new king, haven't they? And they've taken over the nature of government. Okay? But it's wrong. And for anyone to agree to it, is an act of treason. Yeah? And of course, that's not what we're doing here. Everyone here in this room, apart from the MI5 and the Special Branch, they must be there somewhere. And even they, I've known a few blokes that have joined Special Branch, and they were good blokes when they went. I didn't know much about NLP, and I didn't know much about mind control and that sort of thing. But when they went, there was nothing wrong with them. Okay, so that's what's happened here. And here's the next part of this quote. And therefore, as English laws still remain in force, he must necessarily take the crown subject to those laws with all its inherent properties. The first and principal of which was its descendability. Here we then must drop our race of Saxon kings, at least for a while, and derive our descent from William the Conqueror. That's from a new stock who cry by right of war, such as yet still the dernier resort of kings, the final resort of kings, a strong and undisputed title to the inheritable crown of England. Okay? Now, Blackstone's Rights of England, the fifth auxiliary right. And lastly, the right of having and using arms for self-preservation and defence. Is this what you want to hear? Yeah, right. All these rights and liberties is our birthright to enjoy entire, unless where the laws of our country have laid them under necessary restraints. Restraints themselves so gentle and moderate as will appear upon further inquiry that no man of sense or probity would wish to see them slacked. There's nothing wrong with a firearms certificate, as long as the right person gets it. For all of us having our choice to do everything that a good man would desire to do, and to restrain from nothing but what we pernicious to with ourselves or our fellow citizens. Okay. Now I'm going to invite Richard on the platform to take over this microphone. He's going to talk to you about what happened to the right to bear arms. It's still there. It's still there. And then he's going to show you a document that proves what he's saying is correct. If you come up to the stage, please, Richard. This man is a martyr to the cause of the yeah. Okay. Yes. Yeah. Yeah. He's a martyr to the cause. He 30 years ago. He formed a group called the Shooters' Rights Association. Now, chief constables up and down the land. That's the last thing they want, isn't it? Shooters' Rights Associations. No. Okay, Richard, carry on, and I'll just step back.
I didn't invent that name. It was inherited. And it's not that I wouldn't speak to him for 10 years, it's just I was trying to ignore him. So, having had that introduction, the right to keep and bear arms, as John says, is still there. It's hiding in plain sight. Now, I went looking for the source, the root, and in doing that, there's a whole series of stepping stones, which I've got a feeling you already know, so I don't need to spend much time on them. If one was a conveyancing solicitor looking for the authority that the seller has for property, then one goes back through the deeds looking for a good solid root. When we do that with the right to keep and bear arms, it takes us straight back to Alfred the Great and his Domes book. Now, Alfred didn't invent a right to keep and bear arms. What he enshrined was an obligation. The obligation of the individual citizens, the men, was to be prepared to defend the realm in time of crisis. Now, defending the realm in those days meant going toe-to-toe with Vikings, Irishmen, Frenchmen, whoever turned up, and no one is going to go up against any of those invading forces without being properly prepared, without being armed, and without having trained in the use of those arms. So I'm grateful to the Americans for kind of spotting the obligation, as it were, to be trained, though they tend to ignore it because they focus on the later word, the right. So moving on from Alfred the Great, we know that the Norman invasion meant that William took on, as it were, the baggage of our constitution as well as the crown. And Alfred, I think the basis of his legislation was Mosaic law cobbled together with some Saxon statutes. And the Saxon law seems more concerned with property, and the Mosaic law seems more concerned with people. So the principle, as I see it, was Leviticus 19, which says, "Do not pervert justice, do not show partiality to your or favouritism to the great, but judge your neighbour fairly." Now, the idea of it's not fair is understood by every 4-year-old, so it's not difficult. Now, moving forwards, I think the next milestone I came to was, I'll skip Magna Carta just very briefly. John gave a very good explanation of it. He tried to repeal it the following year, and it was Edward I who brought in a statute in 1297 reaffirming Magna Carta. And I noticed that he did that just 1 month after an English army lost a battle at Stirling Bridge to William Wallace. And I bet William Wallace's lawyers had to have a good look at that. Now, so moving on from Magna Carta, the next stage in our constitution, I think, is really Henry II, in the trying to create a common law, a law common to everybody, sending out his judges. He created, as it were, the circuit, what became the Quarter Sessions courts. The judges went out, heard cases in the regions, recorded their decisions, and then those decisions were binding on each other in similar cases. That's the basis of common law, is that one should get the same result in a similar case wherever it is heard. So we can move forwards. The next real milestone, I think, is the Bill of Rights in the 1680s. Doesn't create any law. It reasserts the common law, and in doing that, it's really ending a 150-year period of some turbulence that starts with Henry VIII helping himself to the Catholic Church's money, and we see through that period the development of the Anglican Church and the to and fro between Catholics losing their rights as citizens and James II trying to reassert those rights, and then eventually the Bill of Rights drawing a line under it that common law rights apply to everybody. The right to keep and bear arms was mentioned in there, and this is where we move on from it being an obligation to being referred to as a right. It's not a right until someone takes it away, and then it's claimed back as a right. And what seems to have got lost somewhere in that was the obligation, because having a right to keep and bear arms without an obligation to be adequately trained with it gives you Oscar Pistorius. Irresponsible use of a firearm prejudiced his position. So the right is one thing, but it carries with it an obligation to be properly trained, and that obligation in fact existed as far as the longbow is concerned until quite recently. you may have come across the requirement to practice archery on the village green on a Sunday. I think it's dropped out of fashion, but it is an echo of the obligation. The bowmen at the Battle of Agincourt, 600th anniversary next year, were trained. They were ready to take on an enemy army. They dropped something like 42 tons of arrows on the French in less than 15 minutes. The same number of men at the Battle of Waterloo would have taken about an hour to deliver the same weight of ammunition. So, practice. Right. So, moving on from the Bill of Rights, there was never any great question in British minds that they were entitled to possess arms suitable to their condition, which means what you can afford. You'll notice none of Jack the Ripper's victims were armed. And you have this in the background, the obligation to be trained, to practice. Now, if we touch on the Americans again, when they were drafting the amendments to their constitution, they linked the right to keep and bear arms in the Second Amendment to a well-regulated militia. And the question bounced backwards and forwards for some time as to whether that meant an individual right or whether it meant only as a militia. And the final answer to that was found by referring back to Alfred the Great. I do like it when American courts use English precedent. So, but going back to Alfred the Great, he did not provide the arms, he did not provide the training. People were expected to turn up, ready to take on the Vikings, armed and trained. So it's an individual obligation, not exclusively linked to the militia. It's interesting that so many people in the US didn't want that decided. They preferred the answer left vague. Now, the militia side of it in Britain surfaces from time to time. John touched on it in 1688. The people really became a militia, but they seem to have done it more diplomatically. There are other instances where this surfaces. A good one's 1859, threat of invasion from France. There's the spontaneous formation of volunteer rifle regiments and rifle clubs. National Rifle Associations founded in 1860 to manage, by way of regulating competitions, the training. That was what they did. The threat from France evaporated quite quickly. The volunteer rifle regiments didn't. They stayed in voluntary service until 1908, when the government formalised volunteer militia as the territorial army. And the volunteer rifle regiments, some of them became territorial units, some of them became rifle clubs, and quite a few of them, in my native Walthamstow, what's left of the volunteer rifle regiment is actually a lawn bowls club. Because they were social entities as much as anything else, the sports side took over. We see the militia rise again in 1939. Men in Essex formed the Legion of Frontiersmen. Spontaneously, threat of invasion from Europe. And they did that about 9 months before the government rather belatedly appointed Winston Churchill as Prime Minister, and he called out the militia to be the local defence volunteers, later the Home Guard. So the individual obligation is there. The obligation, as it were, to become the militia is still there. So has it been interrupted? Well, In 1870, the government passed the Gun Licence Act, and any licence is actually a tax. It costs 10 shillings, and it belongs to the same period of raising tax revenue as the dog licence. So, 10 shilling licence to take a gun out of your own house. If you can keep the gun at home, that's fine. If you want to take it out of your house for some purpose, like shooting crows, then that's fine too, but you need a gun licence. Now, 1903, the government passed the Pistols Act, which again created a licence. It was a tax. You didn't have to buy a pistols licence if you already had a gun licence or a game licence. You know, of 3 licences there, all taxes, you only needed one of the 3. So, not that many people use pistols for shooting rooks, but if you had a game licence, then you didn't need the pistols licence. You didn't need it if you just kept the gun at home. So, the next step is the Firearms Act in 1920. This is Lloyd George's government in the post-Great War period. Lloyd George had a number of conflicting concerns, I suppose, not least of which have been rebellion in Ireland. The Great War saw something like 27 royal families made redundant, 4 empires collapse. He was quite nervous about losing his job, and the object of the 1920 Firearms Act was to make sure that only friends of the government had firearms. Working out who his friends were is probably a bit more difficult. During World War I, the government gave away captured German rifles, captured German machine guns and captured German field artillery to the population as inducements to buy war bonds. So if you bought enough war bonds, you got a free rifle. The 1920 Act again creates the requirement to hold a firearms certificate. The debate in the House of Commons at the time indicated that the firearms certificate did not impede your right to keep and bear arms. It had no impact on defence. Certificates were not retrospective, and a number of occupations, principally occupations, were exempted from the need to hold the certificate. People like night watchmen, security guards, bank officers, post office, people that generally were already carrying revolvers in the ordinary course of their duties. The security corps guards shot one of Freddie Furlong's gang dead in 1961 when they tried to raid one of the armoured vans. Post office staff were still carrying guns in the 1970s. So, 1920 Act didn't make a lot of difference, but it did create the requirement to hold a certificate. 15 years later, the positions changed somewhat. Firearm certificates are becoming more the norm. And it wasn't that the exemption was not being recognised, it was simply easier to have a firearm certificate to buy the ammunition, because that was also part of the regulation. So a lot of people took to putting their firearms onto the certificate simply to make the bureaucratic process of buying things like ammunition simpler. Policing went the other way somewhat. There were several amnesties in the 1930s. There was a fairly concerted effort to get the public to hand unused guns in. And then comes 1939, there was a fairly dire shortage of small arms with which to equip the local defence volunteers when they came about. So during the Second World War, every commissioned officer was issued a revolver. they largely seem to have managed to flunk out on the training. You know, the training courses were at Warminster, and nobody, a lot of them don't seem to have gone there, but nevertheless they were carrying their revolvers. You'll notice Field Marshal Montgomery, you will not find a picture of him either armed, you know, wearing or carrying a gun. You know, he didn't like them. Now, after the Second World War, 1968 Firearms Act is a somewhat tightening up. In 1972, a police committee recommended a further tightening up of what civilians could hold, which became eventually the Firearms Act in 1988 after the Hungerford murders. In 1998, Mike Burke applied to the Home Office for an authority for a prohibited weapon, and he was refused as a matter of policy. So he appealed to the High Court, which refused his appeal on the grounds that the Firearms Act impliedly repealed the Bill of Rights. 2002, in the Metric Martyrs case, Lord Justice Laws said that there were ordinary statutes and there were constitutional ones, and an ordinary one could not impliedly repeal the Constitution. If it was repealing a constitutional act, it had to say so on its face. None of the Firearms Acts say anything about repealing the Bill of Rights, so they don't have any impact on it. So taken together, Mike Burke's case and the Metric Martyrs case are clear that the Bill of Rights still exists. I put this into a book in 2011, Does the Trigger Pull the Finger? No one has objected. No one's come back and said I was wrong. In 2014, we challenged the Scottish Government on the subject of is there implied repeal in Scotland, and they came back and said exactly what my book says. So either they've read my book or there is no implied repeal and your right to keep and bear arms is still absolute.
Two more minutes. I'll ask my wife to stand up. Okay? Yeah. And what have you got? Your spray? Right. She's got a self-defence spray, a red dye spray, and she's got full authority for her to carry it in her left hand. Can you see it at the back? It's a British passport. It's a British passport. Okay? Thank you, Tina. Sit down. Okay? Trust me on this. The Home Office put up a document called Firearms Law Guidance to Police. And when I was a policeman, at one point, I was issuing firearms certificates, or doing the paperwork for issuing firearms certificates. It was reissued last year. And here's what it says on this topic. You see that? Firearms for personal protection. Applications for the grant of a firearms certificate for the applicants or another's protection, or that of premises, should be refused on the grounds that firearms are not an acceptable means of protection in Great Britain. Who said so? How many think that firearms aren't an acceptable means? Put your hands up. Who wants to be armed? It's more or less everybody. Well, then it's about half, isn't it? Yeah, okay. To be fair, it's about half, isn't it? Yeah. This is a politician talking, and the politician talking was Roy Jenkins, the Home Secretary, 1969, later found to be a German agent. Now, it was immediately appealed. A man called Sir Richard Greenley has got a big house in Essex, in the country, and he's got a 2.5 auto, which is a small gun, but it's his choice. A 2.5 auto for defending his property, as it happened, his certificate came up for renewal after three years when this instruction came out to the Chief Constable. Sir Richard Greenley goes to court, and the Court of Appeal says, this is nonsense, of course you can have arms for defence. So we've got a judgment as well, so trust me on this. It's been the view of successive governments for many years that the private possession and carriage of firearms for personal protection is likely to lead to an increase in levels of violence. Taking away firearms from people has meant we've got the highest level of violent crime in the Western world, but it's not done with firearms, it's done with fists and feet and edged weapons and clubs. It's still done because we've taken away the only tool to defend. Okay, so if you do a web search for crime statistics, you'll find that the UK has a very high, Scotland has higher actually, because we took away the tool of self-defence. This principle should be maintained in the case of applications from representative banks, firms protecting valuables. That's what Richard was referring to. It used to be if you were the managing director of a bank, you'd have a cabinet of revolvers, and if money needed to be transferred and placed around, you'd issue them to the senior clerk and what have you. That sort of thing. Richard, in fact, worked for the post office in the 70s, and he was trained to use a pistol in regard to transactions of money. How many people knew about that? Hardly anybody. Yeah, hardly anybody. Remember what Blackstone said? Ignorance leads to pusillanimous indifference, doesn't it? Well, let's not be pusillanimous about this. Let's not be pusillanimous about this. A person who's fit to have a firearms certificate, in other words, they're not man or bad, if they want, they should get it. If they want, should get it. And it's only policy that's stopping you. Okay? So if everybody were to apply to their chief constable for a firearms certificate that wants one, what would happen? We'd get a test case, is the bottom line, isn't it? Well, we've got the test case, we've got Sir Richard Greenlee. What happens currently is, if you've got a firearms certificate and know about this, because the community of firearms certificate holders knows about this, has known about it for years, what happens is the police come round and revoke your certificate because you're suddenly a danger to the peace, because you want to defend yourself. And what we've done, what Richard's done for many years, is research this topic, and there's his book. Okay, £10 a time, well worth having. It could save your life one day. Right, any questions about what we've spoken about? Yep. Northern Ireland has still got the right to bear arms. You can have a pistol for self-defence, and there are also shooting clubs that do it on sport. You can also have it in Southern Ireland, you can have it in France, you can have it in Italy, you can have it in Lithuania. We're the only country in Europe that doesn't have the right to bear arms. Okay, if you were to search a French gun shop, for example, they'll have a category on arms for defence. French school children arriving in coaches at Windsor Castle routinely get searched, and they hand over their CS sprays, because a French mum won't send a child out without some precaution. And the policeman goes around in the bag and says, okay, and they get rid of it. Or, as we've now heard, some of them get sold on. We're the only country that hasn't got the right to bear arms. Well, we're not exercising it. Yeah, we've got it, but we're not exercising it, and we're not exercising it through ignorance. Yeah. There's a thing called a European firearms pass, which you can apply for from the chief constable for the area that you're going into, and you can do that in advance. But they won't give you one as a matter of policy if it's a so-called prohibited weapon, which is a pistol. So a long gun, yeah, no problem. Yes, yeah. Any more questions? I'll ask you some questions if you're not careful. I've got a teaching background. Yeah, gentleman there. Armed to the teeth. Now, funny you should say that. There's an article in I've lost it now. I was going to go back. What's the reason British policemen aren't routinely armed with firearms? No. It's 1829. The Metropolitan Police is being put on it's being debated in Parliament, and Sir Robert Peel is the Home Secretary, a good man by all accounts, and he says we'll have a modern statutory police force because the traditional constable is the village constable who's quite often drunk, not much use. So the first question is, what about uniforms? And Sir Robert Peel says, oh no, economy measure, we'll have armbands. And MPs say, no, there'll be spies, they'll be sneaking up on us, got to have a uniform. 1829 is 20 years after the Napoleonic Wars. The Royal Navy's got a large amount of blue cloth in surplus. Get the rest, boys in blue. Then the question of, shall the police be armed? Now, everybody was armed in those days because there was no police force. So MPs objected, and what they said is they referred to Article 5 of the Bill of Rights, which says the Crown can have a standing army in peacetime with consent of Parliament. So an armed police force is a standing army, isn't it? And Parliament didn't accept it in 1829. So the Metropolitan Police acquired a supply of cutlasses, Royal Naval surplus, and pistols, Royal Naval surplus, and they were deposited at the police stations, and the PC could draw one to deal with an incident and then give it back. And that continued until CS sprays became general issue about 10 years ago, because CS spraying law is a firearm. And Parliament was never asked. And a similar thing has happened in Scotland, as you see from the article. So, next question. Yeah, gentleman there. Yeah. You write to the Home Secretary and say, can I have a Section 5 authority? And she would say yes or no. And if they say no, that's your authority to have it without a certificate, isn't it? Because if ever you were accused by a policeman of having a taser without a certificate, you'd call the Home Secretary to court and say, why didn't you give me it? And nobody's done that yet. Yep. What I did too, I handed over 10 pistols. 10 pistols, because I bought some. I had 4 children. There's one each of my sons. I didn't know what I was doing. I supported Mike Burke in his application to the High Court. We got corrupt judges who said the Bill of Rights isn't subject to implied repeal. The answer is you take him to court and sue him for damages. You sue him for damages, because what happens is anyone can commit a crime until somebody gets them by the collar or the throat and says, explain yourself. And of course they can't explain themselves. And this document about the policy is the crippler. Did I see an arm on the left? Yep. Air guns, yes, yep. Yep. Well, it's defence of property, isn't it? So when you say you're shooting on the farm, are you controlling vermin? Yeah, because there's 3 things you can defend: life, liberty, and property. Yeah, okay. So the answer is in the Bill of Rights it says suitable to their condition. Now Richard said it means what you can afford, but it also means type, and it doesn't mean we've got to go back to longbows. It means the weapons of the day, because it'd be a nonsense to expect you to defend yourself with an antique weapon. So if you think a more powerful weapon is needed for that purpose, then it shouldn't be a problem. Yeah. I'm conscious of the time. Yeah. It can be lifted. Speak to Richard about it afterwards. The gentleman's saying he's got a conviction, so does it make him unfitted to be possessing of firearms? There are rules about it. Richard has done some research. Richard and I have done some research. So talk to us about it, and we'll put it on the website so the other people can hear it. Okay? Yep. Justin, right at the back. Yep. Yeah. Sounds good to me. There's a story about a group of students at Oxford University some years ago formed a society to invade and conquer France. And they went to the bank and said to the bank manager, "Well, this is traditional." And the bank manager said, "I've got to agree with you. How much do you want?" Anyway, can we have 2 more questions? Okay, right at the back there. I've got to pack up. Okay, speak to me outside. Richard and I probably know the answer to your questions. We're not encouraging you to go out and form a militia. All we're saying is, if you wanted to, there's nothing to stop you. And you didn't know that before you came to this room, did you? Okay. I'll speak to you at the back, gentlemen. Hand up.
Thank you so much, John. Please feel free to ambush John during lunch. Isn't it funny how the UK basically was the basis for most of the world's constitutions, and yet we're choosing to be willfully ignorant about several things, especially the right to bear arms. And I just thought, while John was speaking, some of our other constitutional rights in the Declaration of Right and Bill of Rights include not only the right to bear arms, free men cannot be imprisoned without cause. The government cannot arrest any man because he disagrees with the government's policies. Do you reckon? Yes, thank you. And finally, government will not impose martial law during peacetime. Yeah, you reckon? So, yeah, that's one to talk over at lunch. I'll see you here in an hour, 2:55, please.